What you know, Alibiers? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Monday, March 3rd. Hope you guys had a good weekend. I was kind of lazy Saturday, didn't really do much, but I did watch Devil in the Family, The Fall of Ruby Franke on Hulu. If you have Hulu, I highly recommend you go check it out. It reminded me of a combination of Mommy Dearest, The Exorcist, and Lori and Chad Daybell. Very disturbing stuff. There's archival footage that shows some behind the scenes stuff that happened in the time that they had their YouTube channel. Ruby really just verbally abusing her kids because they weren't performing like circus animals, essentially. And then it gets really weird once Jody Hildebrandt comes on the scene. I really think that Jody Hildebrandt is the Chad Daybell to Ruby's Lori. I may recap this series for those of you who don't have Hulu, so let me know in the comments if that's something you want me to do. But for today, we're going to catch up on some cases that we've been following. Some of this isn't new news, but it's new to me, so we're going to do it. First off, Keefe D, he is charged in the murder of Tupac, who was shot September 7th, 1996 in Las Vegas, and he died days later on September 13th. Keefe D is the only person who's ever been arrested for Tupac's murder. His trial's been delayed until next year. Keefe D admitted in his book that he was the source of the weapon used to kill Tupac and said he was in the car when the shooting happened. His attorneys now say that book was for entertainment and also for Keefe D to make money. His attorneys have also said he never should have been charged due to immunity agreements he had made with federal and local prosecutors when he lived in California. Prosecution, they say they don't agree because the immunity agreements were limited and they have strong evidence against Keefe D. The judge said she had very little choice due to new developments from his defense team, and the delay ensures he receives a fair trial. His attorneys say critical investigative work needs to be done, as well as interviewing witnesses to ensure he gets a fair trial. His attorneys say a private investigator identified witnesses who can testify Keefe D was not at the scene of the shooting. In spite of his own admission, he was. But that's the latest on that. Moving on to Lori Vallow. She is being interviewed by Keith Morrison this Friday on Dateline. I will be busy Friday from 9 to 10 p.m. There is a very small clip on social media that I've reposted from Nate Eaton where she tells Keith Morrison, I'm going to tell you the truth. We'll see about that. As far as her case in Arizona, Lori filed that motion to dismiss the charges she has in the attempted murder of Brandon Boudreaux, her ex-nephew-in-law. She said it was a violation of the Speedy Trial Act. The judge denied the motion. At a recent hearing, the judge did indicate they would try to get that second trial going as soon as possible, with everybody being ready after coming off Charles Vallow's trial. And in the Charles Vallow trial, the prosecution is asking that anything Tylee Ryan said about the shooting of Charles Vallow be kept out of Lori's trial. In the filing, it says statements made by Tylee would be hearsay and inadmissible. It says the state of Arizona wants to preclude Lori from attempting to admit any statements made by Tylee. Tylee was allegedly outside the residence prior to the shooting and later returned with Lori. Lori was inside Charles's rental car with Tylee for approximately an hour after the shooting and before police were able to interview her. Lori and Tylee drove away from the residence at 7:49 a.m. and returned at 8:48 a.m. The Chandler Police Department interacted with Tylee at the scene during the drive to the police station, and they interviewed her at the Chandler Police Department. Rule 801C of the Arizona Rules of Evidence states hearsay means a statement that the declarant does not make while testifying at the current trial or hearing, and the party offers in evidence to prove the truth of the matter asserted in the statement. Any statements by Tylee Ryan about the incident are out-of-court statements that would be offered for the truth of the matter asserted. Any statements made by Tylee to the defendant, the Chandler Police Department, or any other person about the shooting of Charles Vallow on July 11th, 2019 are hearsay and therefore inadmissible at trial. I'm going to link Tylee's interview she had at the Chandler Police Department in the description below. And before the trial starts on March 31st, I'm going to do a crash course of everything you need to know related to Charles Vallow's murder so that you're ready when her trial starts. In a filing by Lori, she wants the court to deny Court TV's request to live stream the trial. The filing says the defense objects to Court TV's request in its entirety because of the bias they have already created in the community. Namely, Lori Daybell and her husband Chad Daybell are the commercials for Court TV. That commercial runs constantly throughout the day and has falsely characterized and slandered the defendants. Court TV should be ashamed of its very nature and its request, since its sole objective is not to bring people real news or facts, but instead its objective is to entertain the public with the very true life tragedies that happen in real people's lives. The defense objects to Court TV being allowed by this court to participate in this judicial process, including their specific request to appear at trial, live stream the proceedings on the web, and distribute the live feed. We will see. I don't think Lori has had any motion she has filed granted, and I have a feeling this one will be no different. Moving on to Bryan Kohberger. The state has filed a few motions, so let's read through them. The first filing, they want to prevent alternative perpetrator evidence without first satisfying the court that any such evidence is relevant and admissible. They refer to a case, State versus Meister, where the Idaho Supreme Court addressed the standard for admissibility of the alternative perpetrator evidence. They say the Idaho Supreme Court held that the Idaho rules of evidence implicitly overruled State versus Larson. Citing State versus Self, the Idaho Supreme Court noted the trial court must first consider and determine whether the proffered evidence is relevant under Idaho Rules of Evidence 401. The first step is to determine whether probative value of the proffered evidence is substantially outweighed by the danger of unfair prejudice, confusion of the issue, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Noting the Larson court was concerned the defendant will attempt to admit evidence where the sole purpose is to infer that an individual other than the accused committed the crime. The Idaho Supreme Court stated the defendant proffers evidence which merely tends to mislead the jury that another person committed the crime, or the evidence is not relevant because it doesn't tend to make the defendant's involvement. It's within the trial court's discretion to find the evidence inadmissible. Mere speculation that another person could have committed the crime will most likely not be relevant, and if relevant, will still be subject to the limitation provisions of Idaho Rules of Evidence 403. In this case, during the course of the investigation, literally thousands of tips regarding possible perpetrators were received by law enforcement. With the exception of information regarding the defendant, none of those tips were substantiated. The state submits that any attempt by the defendant to offer or argue an alternative perpetrator theory without evidence specifically connecting persons other than the defendant to the homicides would do nothing more than mislead and confuse the jury and would result in undue delay, waste of time, would be a needless presentation of cumulative evidence, and unfairly prejudice the state. Under the Idaho Supreme Court ruling in Meister, this should be prohibited. That's it for that filing. Let's look at another. This is the state's motion in limine about the alibi. They're asking for an order prohibiting the defendant from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from the defendant himself. They cite several motions made by both the state and the defense. They go on to say it's been approximately 20 months since the state made its request for discovery disclosure alibi demand on May 23rd, 2023. The court file reflects the defendant failed to comply with the requirements of Idaho law. The defendant has yet to specify the specific place or places at which the defendant claims to have been at the time of the alleged offense and the names and addresses of the witnesses upon whom he intends to rely on to establish such alibi. They refer to prior filings by both sides. On April 17th, 2024, Kohberger proffered notice of defendant's supplemental response to state's alibi demand. It doesn't comply with Idaho Code and Idaho Criminal Rule or the specific directive of the court's February 23rd, 2024 order, which set deadlines and hearings. Consequently, the defendant should be prohibited from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than the defendant himself. Even were the defendant to attempt to comply at this late point in the time, the state is irrevocably prejudiced. It has now been over 2 years since the homicides occurred and since the defendant was charged. It would be unrealistic at this late date to expect the state to effectively investigate and respond to any new or additional alibi-related disclosures. This is precisely the situation that caused concern for the Idaho Court of Appeals in State versus Juarez. Also, the concerns of the United States Supreme Court in Williams versus Florida, where the court noted the ease with which an alibi can be fabricated and the state's interest in protecting itself against an 11th hour defense is both obvious and legitimate. The Supreme Court held the adversary system of trial is hardly an end in itself. It is not yet a poker game in which players enjoy an absolute right always to conceal their cards until played. We find ample room in that system, at least as far as due process is concerned, which is designed to enhance the search for truth in the criminal trial by ensuring both the defendant and the state ample opportunity to investigate certain facts crucial to the determination of guilt or innocence. For these reasons, the court should issue an order prohibiting defendant from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than the defendant himself. That was it for that filing. We don't have a ruling yet, but I'll keep you posted. The next issue is maybe a new strategy for getting the death penalty off the table. The defense filed a motion to strike the death penalty regarding autism spectrum disorder. It looks like that document may have been sealed, so I didn't see their filing. And let me know if I'm wrong if you guys have it, but I do have the state's response, so let's read through that. They want the court to prohibit Kohberger from offering testimony regarding neuropsychological evaluation and psychiatric evaluation of the defendant as summarized in the defendant's January 23rd, 2025 supplemental response to request for discovery regarding expert witnesses. Specifically, the state objects to the proposed testimony of expert witnesses identified in 2 defense exhibits appended to defendant's supplemental response to request for discovery regarding expert witnesses. They cite Idaho Code 18-2071 and 3. 1 says mental condition shall not be a defense to any charge of criminal conduct. And 3 says nothing herein is intended to prevent the admission of expert evidence on the issue of any state of mind, which is an element of the offense subject to the rules of evidence. They go on to say in each of the witness summaries, the defendant specifically states the testimony is not intended to be a mental element defense pursuant to Idaho Code 18-207. But rather, this testimony is about state of mind as well as factual defense testimony to anticipated testimony elicited by the state. As such, this proposed testimony falls outside of the mental condition evidence allowable under Idaho Code. We'll see what the judge rules, but a lot of the attorneys that I've listened to about this very issue feel it's not going to take the death penalty off the table. Moving on to Diddy. He's facing 4 new lawsuits. The allegations very similar to prior lawsuits. And Anthony Rico, one of Diddy's attorneys, quit the case. There was no reason given, but the attorney did say under no circumstances can I continue to effectively serve as counsel for Sean Combs. In the affidavit, he did say he could not divulge specifics due to attorney client privilege, and the decision was made after a discussion with Diddy's lead attorney, Mark Agnifilo. The filing says this motion for withdrawal of counsel, if granted, will not result in a delay of the present schedule for the commencement of jury selection and trial, or the present schedules for briefing of pretrial legal issues. As a result, there will be no lapse in representation, as Sean Combs will continue to be represented by 5 other attorneys of record. And a judge would need to approve this removal. And just a reminder, Diddy's federal trial is still scheduled for May 5th. So that is the updates for today. Hope you guys have a great rest of your afternoon, and we will see you soon.